welcome back to the show. It is time to get to our viewer questions, and we have some great ones. And we are going to begin with Amy from New Orleans, and she writes, does the mother automatically get custody of her kids in a custody arrangement? John?
Long time ago, that used to be an automatic preference. Not anymore. Right, Bobby?
That's correct. Now there are factors that the trial judge will use to determine what's in the best interest of the child. So there are factors under Article 134 of the Civil Code. It states things like the love, affection, and other emotional ties between the parent and child, the capacity and disposition of each party to give the child love and affection, the ability of a parent to educate the child, the physical distance between the parent's home. And another factor is the preference of the child if the court deems that the age of the child is sufficient for the child to give an opinion. There are actually 12 factors. And one of the factors is not that the mom will get the preference. So you have 12 factors now to be considered by the court.
Well, I know there are probably a lot of dads out there that are happy to hear that, because we know that there are dads who have lots of issues when it comes to child custody. And you were actually saying that at one point there was a law called the tender years?
The tender years doctrine, which indicated that if the child was 5 years or less, there was a preference to the mother, because it was thought that the child's best interest was to be with the mother. That doctrine no longer exists in this state. I'm not sure if it exists in any state.
But let me add, and again, I'm not a domestic law attorney. That's not what I do. I do personal injury and insurance claims. But I know this from years and years ago and from ongoing keeping tabs. A lot of times, still true, dads are working more hours than moms. A lot of moms, because the baby's young and because childcare can cost so much, the mom is the one at home with the kids when the separation occurs. And if one of the factors is who can provide a stable stay-at-home environment, for reasons coincidental more than because moms are automatically considered better caregivers, the courts will say, well, you know, Dad, you're working 60 hours a week on the track to become a manager, and you're out of town a lot. But Mom, on the other hand, she's only working part-time. She can be there when the kid gets off school every day. These are factors that may tilt the scales in her way, but not because she's a woman, not because she's a mother. Okay,
very important to note. Okay, we have a question from Abby from New Orleans. She says, my ex is not following the order in our custody arrangement. Will it cost money for me to have the court enforce it?
Yes, it will cost money. If you don't have an attorney, you have to do it yourself. But to hire an attorney, you have to pay that attorney's fee. There are court costs that you file with the court for enforcing that agreement. And so those costs come out of the litigant's pocket. So there are costs. Unless you get your ex-spouse or the father or mother of your child to agree to sit down in a mediation, or with you alone, you have to pay some costs associated with enforcing that agreement.
Well, if I go through the mediation process and things break down at that point, I still will have to pay, right?
That is correct. You have to pay a mediator.
Either way, you'll have to pay.
The programs in most of these jurisdictions will have a pro bono component where litigants who cannot afford to pay can go to mediators at no fee or a reduced fee.
Okay.
So the fact that some people may not be able to afford it, the local rules would take that into account.
Okay.
Very important. We have the links to how to get to Loyola Law Clinic, Tulane Law Clinic, and other legal assistance corporations on the show website. But to add to that, sometimes if somebody's not following the custody agreement, either you without an attorney or with an attorney, if you end up having to go to court, you can ask the court to not only make the other parent behave and follow the rule, but sanction that person and make that person pay your lawyer fees, your court costs, and a lot of judges, they will. Unfortunately, a lot of parents, they barely make enough money to pay their bills, and it might be like getting blood from a turnip, but you can get an order that says you will behave, you will honor this agreement, or you're going to get in really big trouble, and you're going to pay the attorney fees and the court costs that the other parent spent just forcing you to obey the rules.
Yeah, and I know something else that both of you wanted to make very clear. Even if you go the route of mediation, once a decision is rendered in that process and both parties agree to it, that decision is then entered into the court. It becomes a court judgment, right?
Excellent point.
That is correct. When the parties file it, it has the finality of a judge's decision when it's filed with the court. So the parties have to abide by that decision. Otherwise, they could be held in contempt if a party filed a motion for contempt.
On that note, and you reminded me of a really good point. Maybe you don't go to mediation. Maybe, parents, and goodness gracious, you can both despise each other, but you can both agree you love that child, and you both want the best for that child. For that reason, if you get together and you say, you know what, let's agree. You work it out. Maybe you can do it even without going to mediation. Don't let somebody take advantage, but you work something out. If you work out an agreement even without a mediator, I'll bet you can agree to pay an attorney to go to court and have that judgment turned into some sort of binding agreement.
Okay.
That later on, if somebody says, never mind, I'm mad at you now, I saw you dating this other guy I don't like, I'm not going to agree to the child agreement, you have a binding agreement.
Right.
And you can say, honor this agreement, or I'm going to go after you for attorney fees and costs.
Excellent point. So whether I go mediation or with an attorney, if we can agree and on some sort of arrangement, we can take it to court and it can be binding.
Yeah, and
It
I'm
can
saying
enter.
even if you, on a piece of
On a piece
paper,
of
you
paper,
agree,
you could do
you're going to
that.
get the child every other weekend, I'm going to get the child half the summer, you're going to pay this much, whatever you agree.
But it has
Get
to
a
be taken
lawyer
to
to put
court,
it into
right?
some good format so
Okay.
it's nobody can understand. Your writing is clear. Take it to the court. Turn it into a judgment that both parties sign and agree to. Now you got your rock solid leverage
Right.
to enforce it.
But there are two parts there, and we want to be clear. It's not just writing it. You have to take it to court, and it has to be entered into the court system, right?
I would think so.
That's
Okay,
correct.
That's correct. Okay, let's go to Peggy from Covington. She says, does it hurt my case for custody that I left my husband but let my kids continue to stay with him until I got my own place to live? For 2 weeks, I was living on my mom's couch, and there wasn't enough room for the kids there. So what about Peggy's situation?
That's not going to hurt Peggy. If she allowed the children to stay with the father under those circumstances, that could be in the best interest of the child, and the court will recognize that. So she won't be harmed because she had to make other arrangements for a 2-week period of time.
Okay.
That is not going to hurt her.
That's not going to hurt Peggy. Okay, all right,
agree.
let's go to our next question, which is going to come to us from a viewer who says, what can I do if I think the judge in my case is being unfair and biased against me?
Well, hopefully you had an attorney, and the attorney can guide you in these matters. In my experience, judges on our benches are, by and large, fair. They may make a decision you disagree with, and they're human. They may make a mistake in interpreting the law or the evidence. But if you have a strong feeling about that, and it's something that you believe you have some proof, see if you can find an attorney who agrees with you, and you can take steps with the Judiciary Commission, council that polices judges. Appeal the decision. Appealing the decision is what you normally do if you don't like the decision of the judge. Go to the higher court.
Okay.
Anything to add to that?
I would agree with that. Judges have an ethical duty to be fair, neutral, and impartial. And they have to render decisions that harm some people, or that some people don't like. That doesn't mean that person is being unfair. So I would agree. Check with the lawyer if you have that impression, and then the lawyer can then advise you about what to do.
Okay, well, we are running quickly out of time. I can't believe it. This has been such a great discussion. So before we leave, let's sort of sum things up on maybe the top 3 things that parents need to know out there who are going through this process, whether they get involved with a mediator or they have to go to court or get a lawyer when it comes to resolving issues concerning child custody. What are some of the top 3 things that they need to know?
Let me take a stab at it, and if I left out anything important. Number 1, child custody is handled differently in different courts.
Correct.
Whether mediation is going to be ordered or handled by a hearing officer, if you can get to mediation, it's a no-brainer. Try and do it. Try and convince the other parent to do that. Number 2, remember what's in the best interest of the child. Remind yourself of that, even though you're mad at your ex. Do what's in the best interest of the child. You may be able to work out an agreement a lot quicker and save a lot of money. And number 3, if you're going to find a mediator, you want a court-certified mediator. Bobby actually teaches and trains mediators how to do this, and I think that's the most positive and encouraging message of the entire show.
I would also add, if you have a dispute with the other parent, try to work it out yourself. You are making the decision, and you know what's best for your child. Studies have shown that people who work out their own agreements adhere to those, and they don't go back to court over and over and over again. Whereas when a judge makes a decision, those litigants or those parents are likely to go back time and time again.
All right, great information, Attorney Bobby Harges. So great having you here.
Thank you.
It's so much helpful information out there. We certainly hope that you have learned a lot, and there's more to cover, but unfortunately we are all out of time. So that is it for this edition of John Redmann, Power of Attorney. Be sure to join us same time next week for another great show.
That's right, and remember that if we didn't get to your question on the air, don't worry. We'll try to respond to you personally this week or online. Be sure to check out our website, John Redmann POA, where you can find more information and links to everything on the show today. Thanks for watching. We'll see you next time.